Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. I wanted to report to you an issue that I find a bit disconcerting in my opinion. The fact that there were so many critically important motions in limine that were entertained on April 9th, 2025. Where every member of the defense team were present with Mr. Kohberger. Every member of the state's team were present, including the two newest members, although they did not sit at the state's table. They were in the courtroom that day. It was a marathon day of hearings. This was oral argument on the numerous in limine motions. The briefings that you've been reading that were filed initially on February 21st and on the deadline the 24th, and then the responses and the replies thereto that are so crucial because most of them deal with pretrial rulings. Either the state of Idaho or the defense is asking Judge Hippler to make in advance of trial concerning evidence that the future jury, who will be sitting as triers of fact in this capital case against Mr. Kohberger, will be able to see or not see. We saw everything from in limine motions dealing to the admission of evidence regarding suspect vehicle 1, regarding IgG DNA, regarding Mr. Kohberger's alibi defense, regarding self-authenticating documents that the state wanted rulings on, and so much more. The state's burden of proof, as you are aware, is that they must prove every element of all 5 of the first-degree felonies in this capital case against Mr. Kohberger at beyond a reasonable doubt evidentiary standard, and the evidence, therefore, that's admitted or not admitted is absolutely crucial. Were you aware that the court took minutes down of the April 9th, 2025 in limine oral arguments? They appear on the case summary page, dated April 9th, 2025. Today is the 14th of April. It is 5 days later. Documents have appeared on the docket from the 10th of April. There was an item that was published today that was signed today, an order from Judge Hippler, dated the 14th. But these minutes that have the little PDF icon telling us that these are public documents. When you see the PDF icon on the case summary page as opposed to the lock and key icon on the case summary page, that tells you that the former is a public document, the latter is not. It's under seal. And if you go back to the beginning of the case and look at the case summary page, you will see an astronomical number of documents that have been withheld from the public as being under seal. Now, recently it is true that Judge Hippler ordered that more information should be unsealed. We've seen for the first time in this case recently in these in limine filings such things as actual official photographs of suspect vehicle 1 that the public has never seen. We saw a lot more of the evidence that the state is apparently intending to want to introduce in their case in chief as they attempt to persuade that future jury to return a verdict of guilty in this capital case where the ultimate punishment is possible here. Mr. Kohberger, we must always say, is innocent of all charges under the law until or unless he either pleads guilty or is adjudicated guilty by that future jury. Now, the minutes would tell us such things as officially what the court recognizes, the actual person who's doing the transcribing, who was there, what was said, what was called up first, second, third, fourth, if there were any possible verbal proclamations from the bench of the court, seeming that he gave some verbal rulings already, although there are no written orders. And you may say, well, we can look at the recordings from that day because we can still find them online, certain locations. But that's not the same as a transcript showing that Judge Stephen J. Hippler, for example, made a verbal ruling, a proclamation from the bench that may be reduced to writing in the future written orders. Other information that you'll see in court minutes would be any questions that the court asked that was important, the responses from the defense, the responses from the state, and other data in that marathon hearing. Those minutes must be very long. They've already been produced because they are in the record. They're on the case summary page. And to look at what minutes actually look like, court minutes in Idaho versus Kohberger, I have provided you with an example of minutes that were previously published when this matter was in Latah County following a hearing. And you can see the sort of documentation that the transcriptionist, apparently the court reporter for the county, this was Latah County, now for Ada County for this still unpublished April 9th, 2025 minutes from hearing that day. So the question just remains that this document was published. It appears on the case summary page before other items that were docketed on the case summary page by the Clerk of Court. That's what the case summary page is for. The clerk receives the official filings in this case, all of the important key events, notices of hearings, motions, responses, replies, court orders, and minutes. And so why, I ask, are the minutes still not published when other documents that were published later have already appeared on the docket? Do you have any questions or comments? I would greatly appreciate hearing from you. All of your feedback is always appreciated. And if you could like the content, if you do like it, and subscribe to the channel, it would help us out a lot. This will now conclude this episode of the Indie Zone. I will, of course, continue to monitor the docket for when these minutes are published, and will report back to you with what they say. Until then, this is Kathy. Thank you for joining us here today at the Indie Zone.